So today in this class we will be discussing criticisms of fundamental rights. So on what basis we have criticized fundamental rights? These are the basic things we have to know. So just to brief this, we have excessive limitations on fundamental rights. దీనినే మనము మితిమీరిన పరిమితులు అంటాము. ఒక చేతితో ఫండమెంటల్ రైట్స్ మనకు ఇచ్చినట్టే ఇచ్చి ఇంకో చేతితో బ్యాక్ తీసుకున్నారు. సో చాలా వరకు మనం చూస్తాము. ఫర్ ఎగ్జాంపుల్ ఆర్టికల్ 19 క్లాజ్ 2లో మనకి కొన్ని గ్రౌండ్స్ విధించారు. ఏ గ్రౌండ్స్ మీద అయితే ఫండమెంటల్ రైట్స్ని పార్లమెంట్ లిమిట్ చేస్తుందో, సో మనం చూసుకుంటే సావర్నిటీ అండ్ ఇంటిగ్రిటీ ఆఫ్ ద స్టేట్, సెక్యూరిటీ ఆఫ్ ద స్టేట్, డిఫేమేషన్, కంటెంప్ట్ ఆఫ్ కోర్ట్, ఇన్సైట్మెంట్ ఆఫ్ అఫెన్సెస్, ఇలాంటివి కొన్ని గ్రౌండ్స్ మీద పార్లమెంట్ లిమిట్ చేయొచ్చు, ఫండమెంటల్ రైట్స్ని నియంత్రించవచ్చు. సో ఇలా మనం ఒక ఆర్టికలే కాదు, ప్రతి ఆర్టికల్లో మనకి కొన్ని లిమిటేషన్స్ ఉంటాయి ఫండమెంటల్ రైట్స్ మీద. సో ఎక్సెసివ్ లిమిటేషన్స్ రైట్ ఫ్రమ్ ఆర్టికల్ 14 టు ఆర్టికల్ 35. ఇన్ ఎవ్రీ ఆర్టికల్ దేర్ ఆర్ సర్టెన్ లిమిటేషన్స్ ఆన్ ద గ్రౌండ్ ద Parliament can restrict the enjoyment of fundamental rights to all the citizens. So we have excessive limitations. All these things we will be dealing in detail. So no social and economic rights. మనకి మొత్తం ఫండమెంటల్ రైట్స్లో చాలా వరకు సోషల్ రైట్స్ కానీ ఎకనామిక్ రైట్స్ కానీ ఎక్కువ శాతం కనిపించదు. చాలా వరకు పొలిటికల్ రైట్స్ మాత్రమే మనకి కనిపిస్తుంది. సో నో సోషల్ అండ్ ఎకనామిక్ రైట్స్. వీ హ్యావ్ మోస్ట్ ఆఫ్ ద రైట్స్ ఆర్ పొలిటికల్ ఇన్ నేచర్. సో నో క్లారిటీ హియర్. It is clear that the words in the fundamental rights do not contain a clear meaning. The words are ambiguous. So interpretation would become difficult. High Court or Supreme Court will face many challenges in interpreting certain words. So we can say that the words or the fundamental rights themselves are not clear. స్పష్టత లేకపోవడము, ఎక్కడ ఒక క్లియర్ మీనింగ్ అనేది కన్వే చేయట్లేదు. నో పర్మనెన్సీ. మనం చూస్తాము కొన్ని ఫండమెంటల్ రైట్స్ని సాక్రోసాంక్ట్ అని చెప్పము, అది టెంపరవరీగా ఉంటుంది. ఎవరైనా అంటే కొన్ని సందర్భాల్లో పార్లమెంట్ దాన్ని రిపీల్ చేసేయచ్చు. సో చాలా వరకు మనం రైట్ టు ప్రాపర్టీ చూసాము, ఇట్ గాట్ రిపీల్డ్. సో పర్మనెంట్ అనేది లేదు. అండ్ వీ ఆల్రెడీ డిస్కస్ దట్ fundamental rights are not sacrosanct, they are not permanent, they can be modified, they can be repealed, or they can be taken away by the authority of law. So this is also one of the critics that fundamental rights are not permanent. So this we have seen suspension during emergency. In times of emergency, fundamental rights could be suspended. So ఎప్పుడైనా కామన్ కండిషన్స్ కాకుండా ఒక అన్సర్టెన్ కండిషన్స్ ఉన్నప్పుడు, అబ్నార్మల్ కండిషన్స్ ప్రివేల్ అయినప్పుడు, లా అండ్ ఆర్డర్ బ్రేక్ అయినప్పుడు, లేదంటే మనము వేరే కంట్రీతో వార్లో ఉన్నప్పుడు, అలాంటి సందర్భాల్లో మన ఫండమెంటల్ రైట్స్ని సస్పెండ్ చేయడం జరుగుతుంది. సో అత్యవసర సమయంలో సస్పెన్షన్కి గురి అవుతాయి ఫండమెంటల్ రైట్స్. అందుకే మనం చెప్తాము ఫండమెంటల్ రైట్స్ ఆర్ నాట్ పర్మనెంట్. సో దీస్ ఆర్ వెరీ ఎక్స్పెన్సివ్. If anyone has a complaint, like anyone's fundamental right got violated, then such person, if he needs to go to Supreme Court or to go to High Court, so that is a very expensive process. He should hire an advocate, and advocates generally they charge a lot of money. So to ensure that our fundamental rights are protected, which are guaranteed by the Constitution, but to ensure their protection, it is very expensive. So going to court, moving the court, and it takes a lot of time in the court. So ఇది చాలా ఖరీదైన పని, very expensive. We have seen many people are still lodged in so they've been arrested, detained, lodged in cells, jails, because they don't have money to hire an advocate. So it's emergency. In emergency situations, we can see that many people got detained, and for their bail, to get a bail, they need an advocate, a lawyer, who generally charges a lot of money. So we can say that this remedy is not viable for poor section of the people. They cannot afford these legal things. So we can say that it's very expensive. Preventive detention is one such thing where we cannot ensure that our fundamental rights being protected. So preventive detention is a clause in fundamental rights only. We have said that it's a process where any person could be detained before he indulges in any crime. So if any person on suspicious basis, the police can arrest and detain a person. So obviously this kind of clause is against fundamental rights. It is against Article 22, where we say it is unlawful to detain any person without any trial. So this is an exception, but it is definitely a limitation on fundamental rights. So on this basis, fundamental rights has been criticized. So no consistent philosophy. This is one thing which is been criticized by the critics. We say that in entire fundamental rights, we need to follow certain philosophy in our constitution also. But fundamental rights has no single clear-cut philosophy. In some areas, we talk about socialism. In some areas, we talk about, humanism, capitalism, all. So definitely, there is no single philosophy which is leading the entire fundamental rights. So again, this is a chapter of confusion which led many critics to criticize the fundamental rights. Going into detail, so when we say excessive limitation, first thing is fundamental rights are justiciable. They are justiciable in the sense any person who gets violated of their fundamental rights can move Supreme Court or High Court. So one thing is we know every citizen is aware that if any action of the state or any public authority which takes away or abridges the fundamental rights, then such action could be made invalid by Supreme Court or High Court. That is one clear thing. But within the fundamental rights, we have seen many such clauses which they themselves put restriction on the fundamental rights and on their applicability. So there are many limitations on the applicability of fundamental rights. We say the state has clear thing that there should be a fundamental right, every person will enjoy fundamental right, but on certain basis they are curtailed. So in all the fundamental rights, right from Article 14 to Article 35, all fundamental rights are subject to some sort of restrictions placed by the state. On the same thing, there are many cases which are in Supreme Court, and Supreme Court has given many judgments. There was always a continuous type of struggle or war between Parliament and Supreme Court. Parliament will come with certain law which obviously takes away fundamental right of a common people or a citizen. Then they will approach Supreme Court or High Court. Then what happens? The Parliament again amends the fundamental right and adds some clause or some provisions in that. So the state's action in general has taken away the liberty or the freedom to enjoy the fundamental rights. We know right to property is one such fundamental right, where on that particular clause there were a lot of cases in Supreme Court. So there are many restrictions, there are innumerable exceptions, qualifications and explanations regarding right, that is fundamental right. So we can say that Constitution has granted fundamental right, but it has more exceptions in fundamental rights. It has more exceptions regarding reservations, regarding many exceptions which are applicable to some person and which are not applicable to some other persons. So there are many exceptions. For example, in Article 31A, 31B and 31C, these three articles have a lot of exemptions. That is, when a state acquires or takes away the land, those people who have lost their land cannot move Supreme Court because it is based on the reason is agricultural reforms. Or when we say that right to property, no one should go to court regarding right to property. So we have repealed that right to property and we have made only as a legal right, that is a ordinary right under Article 300A. We have many such exceptions in all the fundamental rights. That is the reason why critics have called this as excessive restrictions on fundamental rights. They have criticized fundamental rights on the basis of excessive restrictions, exceptions, explanations, etc. So, Jasprit Rai Kapoor has said, it is not a list on fundamental rights, but a list on exceptions on it. So, the extent of fundamental rights we generally see, there are many fundamental rights. At the same time, every fundamental right have its own exceptions, its own explanations, and its own restrictions. So all these things have made fundamental rights very confusing. No social and economic rights. See, when we read fundamental rights right from Article 14 to 35, we generally seldom see rights on social and economic rights. Most of the things are specially regarding political rights of the citizen. So one thing we need to understand is, unless there is a right for economy or right for social good things, we cannot achieve political rights. If any citizen is not given economic right to prosper, what will he do with the political rights? That is the reason now in our democracy we are seeing a lot of inequalities. People have political right in the terms of voting, like we have universal adult franchise. Every person who has achieved 18 years of age, who have crossed 18 years of age, can vote. But what if they do not have economic independency? What they do not have the way to earn? So they generally are misguided by these political parties. So every citizen, every common people, every common person should have both social and economic rights. So in this fundamental rights, we generally see most of the rights are social, that is political rights, but not socio-economic rights. So what about that social economic rights? Right to social security. Social security is like we need to have, any person need to have three common things like shelter, food and work. So very rarely we see that fundamental rights has provided that with us. So right to work, right to employment, right to rest and leisure. Of course, these are mentioned in directive principles of state policy, but in fundamental rights we have given more sort of political rights. That is, on that basis critics have criticized fundamental rights. That is, fundamental rights what we have in our constitution in part 3 are giving more importance to political rights but ignoring social and economic rights. No clarity, స్పష్టత లేకపోవడం. In our fundamental rights, many words are there which are not clearly defined. There are many words or the many statements which do not carry clear meaning. For example, we have public order. Public order, it is mentioned in Article 19 Clause 2. On the basis of disturbance or to public order, state could impose restrictions on right to freedom. So then what is public order? Many people can interpret public order in their own words. So we do not have a clear definition of public order. Even the word minorities has not been explained in details. We have a confusion with minorities. We may say religious minorities, linguistic minorities, but there is no clear explanation of the word minorities. Reasonable restrictions. Reasonable restriction is also a word where the parliament will restrict on the enjoyment of fundamental rights. It says we have reasonable restrictions. So what is reasonable? Reasonable is a relative term, and to find that the restriction placed on the fundamental right is reasonable or not reasonable. That is, again, the court should interfere. The court should decide that the restrictions imposed are whether reasonable or not reasonable. But neither anywhere it has been explained that what reasonable is. రీజనబుల్ అనే వర్డ్ని ఎక్కడ ఒక స్పష్టంగా ఎక్స్ప్లెయిన్ చేయలేదు. సో దానివల్ల ఏమవుతుందంటే కన్ఫ్యూజన్ క్రియేట్ అవుతుంది. దేర్ ఇస్ ఎ లాట్ ఆఫ్ అంబిగ్విటీ. అది హైకోర్టు కానివ్వండి, సుప్రీంకోర్టు కానివ్వండి, ఆ వర్డ్ని ఇంటర్ప్రిట్ చేయడంలో ఒక అంబిగస్ నేచర్ ఉంటుంది, ఒక కన్ఫ్యూజన్ క్రియేట్ అయిపోతుంది. సో ఇలాంటి వర్డ్స్కి ఎక్కడ క్లియర్గా ఎక్స్ప్లెనేషన్స్ ఇవ్వలేదు. అందుకే మనం చెప్తాము క్లారిటీ లేదు, ఒక స్పష్టత లేకపోవడం వల్ల ఈ విధంగా క్రిటిక్స్ ఫండమెంటల్ రైట్స్ని క్రిటిసైజ్ చేశారు. సో పబ్లిక్ ఇంట్రెస్ట్ కూడా అలానే సింపుల్, అది అంబ్రెల్లా వర్డ్, అది పబ్లిక్ ఇంట్రెస్ట్ అని. ఎక్కడ కూడా పబ్లిక్ ఇంట్రెస్ట్ అంటే ఏ పబ్లిక్కి ఏ ఇంట్రెస్ట్ అనేది ఎక్కడ చెప్పలేదు. సో దీని పరంగా మనకు అది ఇంటర్ప్రెట్ చేయడం అనేది చాలా కష్టమైన పని. ఓన్లీ లాయర్స్ ఆర్ ఏబుల్ టు అండర్స్టాండ్ దీస్ వర్డ్స్. దట్ ఈస్ ద రీజన్ వై సర్ ఐవర్ జెన్నింగ్స్ హ్యాస్ కాల్డ్ దిస్ ద కాన్స్టిట్యూషన్ ఆఫ్ ఇండియా ఈజ్ అ ప్యారడైజ్ ఆఫ్ లాయర్స్. Only lawyers are able to understand. Even they are also find difficulty to understand the words mentioned in the constitution, because the constitution has written by legal luminaries who were barristers, who studied in London. So it is very difficult at our level to understand the constitution and the words in that. So we can criticize the fundamental rights on lack of clarity, clarity, and it is ambiguous. That is, we can interpret those words in different way. So no permanency, as we say, the fundamental rights are not permanent, they are not sacrosanct. So in times of emergency or in any other times, these fundamental rights can be abrogated, can be repealed, can be modified. So they are not permanent. The parliament can curtail or abolish them. Example, abolition of right to property. Right to property has been abolished. It was under Article 31. It was abolished. It was also under Article 19 Clause F. So the right to property was abolished. So we can say that fundamental rights are not permanent. So these tools, because they are not permanent, because parliament has the power to take away fundamental rights at their will and wish, so that becomes a play tools in the hands of politicians. When they are in majority in the parliament, they might take away the fundamental rights. But the judicial review, as we say, the basic structure is one thing which acts as a limitation on the arbitrary power of the parliament. Otherwise, we can say that fundamental rights are not permanent. So these can be suspended during emergency. అత్యవసర సమయాల్లో వీటిని సస్పెన్షన్ చేయవచ్చు. సో సస్పెన్షన్ ఆఫ్ ద ఎన్ఫోర్స్మెంట్. So we have fundamental rights, but we cannot enforce them. No one whose fundamental rights has been taken away could go to court and ask for their enforcement, though, because their enforcement has been suspended at times of national emergency. So we can say that many people are still lost in the jail because they have been punished, they are led to punish, and they cannot move the court. So they are under jeopardy, that is, they are facing punishment. So what critics say that, as per the critics, fundamental rights should be enjoyed in all times, be it normal or abnormal. So fundamental rights are fundamental things for the growth of individual and also for the society. So what critics says that, or experts of the constitution say that, in emergency times also fundamental rights should be enjoyed by the citizen. Obviously, because in normal circumstances there is no harm for fundamental rights, but in times of emergency only many of the fundamental rights will be taken away by the state. So what critics say that in times of emergency only there is a need to have protection for their fundamental rights. So this is very expensive, chala kharidainadi. When we say fundamental rights are very difficult to understand, and to make sure that our fundamental rights are protected, and if at any time our fundamental rights has been taken away, we should move the court. Now moving the court, going to the Supreme Court or High Court is not a simple thing. Our Supreme Court is at Delhi. So people living in down south cannot go to Delhi, stay there, hire an advocate, take an advocate and file petition in the court. So it's very expensive process. So to protect our own fundamental rights, you need to have a lot of money. So it's very expensive. You need to have a lot of time, patience and all. You have to fight with someone who is more powerful than you, more mightier than you. So definitely it's an expensive process. So judicial process is too much expensive, as at one hand Supreme Court says that yes, we take your petitions, but to file the petition we need a lot of money. So critics say that rights benefits the rich sections of the society, but poor man cannot afford the expensive judicial process. So rich man obviously he can afford. So here the poor people have disadvantage when they want to go to court for the protection of their own fundamental rights. So it's a thing when we say that Article 22 says that illegal detention is not right. If any person is detained, then he should be produced before the magistrate or court within 24 hours. And again we say that there is a other class, preventive detention. What preventive detention? In this case any person can be arrested and detained, and he could be detained for at least 3 months. More than 3 months they should have a advisory report. So advisory committee should extend that period, but for 3 months they can be detained. So it again violates Article 22. But what this says is preventive detention. It is a clause to stop or to prevent any untoward activity or to secure law and order in future. But again this is an arbitrary power, and it is also most misused provision in the Constitution. It has an arbitrary power in the hands of the executive agency, who could easily detain any person on the suspicion basis. So arbitrary powers on the states and negates individual liberty, because here when we say Article 22, that is detention, preventive detention, it negates Article 21, right to life and personal liberty. So no democratic country in the world has preventive detention clause. That is, at times of normal conditions prevailing also, no democratic loving country or freedom loving country, democracy, have these kind of provisions. They have certain provisions, but that is in times of emergency. But in our constitution, even in normal times also, any person could be detained and held for many months. So this is a unique concept. The reason is we are preventing the untoward situations or any situations which causes or damages the national integrity or security of the state. So on that basis, many people have been detained. So we say that no consistent philosophy. See, every constitution has its own philosophy. We have borrowed many things from different parts of the constitutions of the world. So obviously in our fundamental rights, no single philosophy has been followed. So critics have criticized that we do not follow a single philosophy. So Albert Jennings said fundamental rights proclaimed by the Indian Constitution are based on no consistent philosophy. There is no consistent philosophy in our fundamental rights. We have socialist philosophy, we have Gandhian philosophy and such other philosophies. So it is very difficult for Supreme Court and High Court to interpret fundamental rights, because we can see that the words mentioned in the Constitution has no clear meaning. They are ambiguous. They don't convey a clear meaning. So it would become difficult for the interpreting body, that is High Courts and Supreme Courts, would find it difficult to exactly interpret the words. So these are the things on the basis of which the fundamental rights has been criticized. It is not that fundamental rights are not advantageous. Yes, we know that fundamental rights are very much important for individuals' growth and also for the growth of the country. But we also have certain negative aspects when it comes to fundamental rights. That is, too much of restriction, too much of exceptions and explanations. And we also know that the words are not clearly mentioned, and whoever whose fundamental rights are being violated, and they should move the court, which is an expensive thing. So all this also a part which should be gradually taken away. So critics has been criticized on these aspects. So this is the gist of criticism of the fundamental rights.